My name's Tim Parker and I head up the family law team. The purpose of this seminar is to bring you up to date, we hope, with some emerging areas of law. Normally we would prefer to be doing this in person and to be meeting you and greeting you in chambers. But due to these very strange times that we're living in, that's not possible. But we thought that this would be a good opportunity to be able to keep in touch with you and keep you up to date with practice, which I hope for all of you is racing ahead. It certainly is for us, even though that now tends to be taking place by remote, either video or telephone conferencing facility. So we're all having to become experts in one way or another in Zoom and Microsoft Teams and all these other strange ways of keeping in touch. So this afternoon we have two speakers from Chambers, Kate Lamont, who is a practitioner of just over 10 years call. She has a wide family practice which involves all areas of both children and money-related work. She has particular interest in cases where the police become involved in family proceedings, often in heavyweight care applications where disclosure issues arise, both between the local authorities and also the police. Today she's going to be speaking to us about secure accommodation orders and the recent rash of jurisprudence that has developed around them. After that, Tom Jones will be speaking. Tom is 2015 call and has a practice in all areas of Chambers family work. He is recently returned from advising the Welsh Government on matters relating to the deprivation of liberty, which is what he's going to be speaking to us about this afternoon. As far as the running of the seminar is concerned, the chat feature is hopefully at the bottom of your screens towards the center, just next to the share screen feature. Please feel free to send questions while Kate and Tom are speaking, and I'll try and gather them up towards the end of the afternoon. Similarly, when we've finished speaking, we will hover online, so to speak, and try to deal with any queries and questions that arise. So welcome again to all of you. It's great to be speaking to people right across the country, I think from Cumbria all the way down to Oxfordshire, as well as London. I now invite Kate Lamont to speak first.
Thank you very much, Tim. I am going to talk today about secure accommodation, and I'm going to do that by looking first of all at the statutory framework, just to set up the context for some of the case law update that I'm going to go on to provide. The cases I'm going to look at are Re D, which is as you will all be well aware, not a case strictly speaking on secure accommodation. It's a case really that looked at deprivation of liberty and consent to deprivation of liberty, but it set up the case that I'm going to talk about afterwards, which is Re B, which is a Court of Appeal case which really has really completely changed the way that any application for a secure accommodation order should be approached. When I say change, what I mean is it's clearly defined how it should be approached in a way that hadn't really been done before. So it's done a bit of a perhaps re-BS job on the issue of secure accommodation. I'm then going to come on to look at some recent judicial responses to the perennial problem that is the shortfall in the provision of secure accommodation. So Mona, please can I have the first slide? Thank you very much. So the statutory framework, the overarching provision in relation to secure accommodation is section 25 of the Children Act. That is a general prohibition on a local authority placing a child in secure accommodation unless specific circumstances arise or relevant criteria are met. And what that section does is it initially sets out two criteria, that being that the child has a history of absconding or is likely to abscond from any other description of accommodation, otherwise, and if he does, he will suffer significant harm, or alternatively, that if he is kept in any other description of accommodation, he's likely to injure himself or other persons. So it is for the court to determine whether the relevant criteria, which I will come on to discuss in detail in relation to Re B, are met. And if the court determines they are met, the court must make the order. It doesn't have a discretion. The court can make an interim order under section 25(5). The child must be legally represented or have refused legal representation, which is an important point because it means that it's not possible to make an application for a secure accommodation order to be heard before a child who's absconded has been recovered, because obviously in those circumstances they would not have had an opportunity to become legally represented. So that is important. The Act itself, section 25 itself, is supplemented very heavily by regulations, which means that if you just turn up section 25 in the red book, you won't necessarily get a very clear picture. So Mona, could I have the next slide, please? The regulations, the relevant regulations are the Children's Secure Accommodation Regulations 1991, which you'll see are now almost 30 years old. So they have been much amended over the years, most recently by the Children and Social Work Act 2017, in particular Schedule 1. The key points that come out of those regulations are the one that I suppose we'll all be very aware of and will have heard all the time, certainly in relation to issues surrounding with the shortfall in provision, is that accommodation in a children's home must not be used as secure accommodation unless it's approved by the Secretary of State for that use. That's Regulation 3. The provisions under Section 25 do not apply to children who are detained under the Mental Health Act or children who are accommodated under the Children Act Section 25. Section 25 relates to children who are 16 and over, 16 to 21, who are being looked after by the local authority for the purposes of safeguarding or promoting their welfare. So, but there is another provision under Section 23 that you'll be aware of, which also allows the local authority to accommodate children where it's found that or thought that their welfare would be severely prejudiced by not being accommodated. Children accommodated under that part can be made the subject of a secure accommodation order. So it's important to differentiate between the two if you have a child who's over 16 and is being looked after. Of course, what this obviously covers is children who are the subject of care orders. It applies to some additional categories of children as well who are not looked after by the local authority, including those looked after by some health authorities and education authorities under Regulation 7. So that slightly changes the strict wording of Section 25, which refers specifically to children looked after by local authorities. A child can only be kept in secure accommodation for an aggregate of 72 hours over 28 days without the authority of the court. So that means, of course, that when a child is recovered, if they've absconded and you've made your application to the court, you need to make sure that that application is made to the court and brought to the court within 72 hours. Special provisions are in place if that happens over a weekend or a bank holiday. So it's worth looking up if any of those issues arise. The maximum period a child can be kept in secure accommodation is 3 months in the first instance, and thereafter the court can authorise an extension for a period of not exceeding 6 months at any one time. Please can I have the next slide, Mona? Mona? Oh, hello. I seem to have, oh, sorry, got the next slide, thank you. So the statutory framework in relation to children's homes, this is relevant mainly insofar as it helps explain to some extent why there is such an issue here. It is in relation to provision and shortfall. The Care Standards Act makes it a criminal offence to run a children's home without appropriate registration under Section 11. And so that's really the sort of baseline in which a lot of the applications that have been made for deprivation of liberty are being made, because they're being made in relation to homes that are not approved. So the regulations as well that come under the Care Standards Act provide some guidance in relation to deprivation of liberty, and you can see there at Section C that a child who is accommodated in a secure children's home can be restrained and prevented from absconding, whereas a child who's not in a secure home cannot be, which is why certain care providers are quite clear that they need to make sure that a care plan does not include anything which suggests that they need to try and prevent the child from absconding, because to do that, if they're not registered as a secure children's home, would be in breach of these regulations. But these regulations do not prevent a child from being deprived of their liberty. So if you do need to go and make an application in relation to an unapproved setting, then that can allow these regulations to be regularised effectively. So I would like to come on now to talk about Re D. So if I could have the next slide, Mona, please. As I said, Re D is not, strictly speaking, a case about secure accommodation, and I'm not going to try and steal Tom's thunder by going into it in any detail. But it is important because it really did provide, in some respects, a springboard for Re B. This was the first time that the Supreme Court or the House of Lords before it had actually considered the issue of Section 25. So it's really the only highest order judicial authority, or not authority, but guidance that we have in relation to Section 25. Lady Black decided that it was important to consider the scope of Section 25, even though the issue that the court was considering was whether or not parents could consent to a deprivation of liberty effectively, because if Section 25 applied in that case, it wouldn't matter whether the parents could consent to a deprivation of liberty, because it would be being governed by Section 25, so it wouldn't matter, consent wouldn't be an issue. It would be for the court to examine it and decide whether the relevant criteria are met, and if so, would make the order. So that is why she considered it. And she asked, I think, the parties, after there had been argument in the court, to come back and provide, well, to provide some written submissions in relation to the issue of Section 25. So this was one of the submissions that was made on behalf of the Secretary of State in this case was that it was easy to identify what secure accommodation was, because it would be accommodation that was approved by the Secretary of State. Lady Black made it quite clear that it couldn't be quite so narrowly restricted to that. And I think this judgment, if you read this judgment of hers from paragraphs 91 to 115, it provides a really lovely summary of the case law and also the statute and the provisions in relation to Section 25. So it's worth a read, even though it's not strictly speaking a judgment that was looking specifically at it. But what she does identify there, and it's in the quote that I put there, is that whilst it can be readily be accepted that the intention is that only properly authorised children's homes are to be used as accommodation for purposes of restricting liberty, it does not necessarily follow that, in practice, a child could not find him or herself placed or kept in a children's home which, but for the fact it does not have the Secretary of State's approval, has every appearance of being secure accommodation. If the argument advanced by the Secretary of State is right, such children might be doubly prejudiced, i.e. placed in an unapproved children's home and outside the protective regime of Section 25. Given the shortage of approved secure children's homes highlighted by the Court of Appeal in Re T, this is a risk which cannot be ignored. So Lady Black wasn't keen on such a narrow definition as that. Can I have the next slide, please? Thank you. And in this paragraph, another important takeaway from Re D in relation to secure accommodation is this point, and that's that this was sort of hidden away. It wasn't a major part, and it hasn't been reported very highly. But what Lady Black did pick up on was that no question had been raised in Re T about whether it was proper for the High Court's inherent jurisdiction to be used to authorise restriction of liberty in an unapproved children's home, which does make some sense when you think about it, because strictly speaking, what you're doing by authorising a restriction of liberty in an unapproved children's home is authorising the commission of a criminal offence in some respects, because it's a criminal offence to have an unapproved children's home. So I think that is an important point. No one has picked up on it very much, but it does beg the question whether or not there was sort of some way, perhaps an invitation to argue this point at some stage in the future for somebody. Lady Black, of course, was a High Court judge of the Family Division, so it's not just her not quite understanding the difficulties of this situation, so I think that's quite an important thing. I'm not going to go into more detail about what she said about secure accommodation, because that's covered quite heavily in Re B, and Lord Justice Black does actually transcribe a huge chunk of her judgment. So Re B is the main case that I'd like to speak about today. This was an appeal from a refusal of a local authority's application for an order under Section 25. I'm going to briefly outline the background to it. This involved a 15-year-old girl who had not been known to social services until about a year before this came before the court. She had made an allegation of sexual abuse against an individual, but she then made further allegations against her mother and stepfather. She assaulted her mother and stepfather. She absconded on several occasions and appeared to be at risk of CSE. She had a lot of the hallmarks of a number of the secure accommodation cases that land on our desks. Eventually, she was placed in a children's home under Section 20, but things became more extreme. She started she attempted suicide, and so more significant action needed to be taken. The local authority started looking for a secure placement, an approved secure placement, but as is often the case, that process was not one that was able to be achieved overnight. So what happened was that she was placed in a children's home which had been approved for some older children with autism, I believe. It wasn't approved as a secure children's home. It was known as N House, and it's referred to as N House in the judgment. She initially attended school from there. She then tried to abscond from school, so they stopped taking her to school. And so she was effectively being held in this secure, in this placement in a way that quite clearly placed some restrictions on her liberty. And the court and the local authority duly applied to the court for an order under the inherent jurisdiction enabling them to do that. They then found a Section 25 compliant approved placement for her, which was on the south coast, which I understand was some distance from where she and her family lived, and they went to the court to make that application. That was opposed by her parents and by the children's guardian, and the judge was therefore faced with a little bit of a difficult dilemma, because it was quite clear that she really did not want to go to this alternative placement. She was happier where she was. And one of the arguments that was advanced on behalf of the children's guardian was that she hadn't absconded from N House, and that could fall under the description of any other form of accommodation, and because she hadn't absconded, therefore the test couldn't be made out. The local authority said that was wrong, and that in fact actually secure accommodation, that N House was secure accommodation, and could be rightly described as secure accommodation. So the court identified 4 questions that I've set out there. I'm going to come on to look at each of those 4 questions in turn. So first of all, what is the meaning of secure accommodation? This was important on the facts of this case, because of course what was effectively being argued was that the accommodation she was in was not secure accommodation, and so that was the basis upon which the judge at first instance had refused the local authority's application. And so that is why it was important to look at this. And Lord Justice Baker considered in some detail what Lady Black had said about secure accommodation, the definition of it. And I've set out there what he said about it, which was that in his judgment, in accommodation designed for or having its primary purpose the restriction of liberty, in my judgment, secure accommodation is accommodation designed for or having as its primary purpose the restriction of liberty. As Waldeck acknowledged, however, premises which are not designed as secure accommodation may become secure accommodation because of the use to which they've been put in the particular circumstances of the individual case. So that made N House had become secure accommodation in the circumstances of this particular case. If I could ask you to just move on. Thank you. So the court, the third, I'm going to come on to the second question that the court asked itself about what the relevant criteria were, what the scope of them were at the end, because that's really what sets out the full tests that the court needs to apply now. But the court also did consider what the evaluation, what role the evaluation of welfare had to make in the court's decision making, and also what evaluation of proportionality had to be made in relation to the relevant criteria. This had been the topic of some differences of opinion within practitioners, some of whom believed effectively that Section 25 had its own safeguards built into it and could just be applied strictly as the letter of the law, and others who were of the view that actually there did need to be some welfare evaluation and, of course, a proportionality evaluation. Of course, we have to remember that Section 25 was pre-Human Rights Act, and so, of course, the focus on the court being obliged to consider Human Rights Act issues is perhaps more pertinent now than it was when the Act was drafted. But what the court decided was, referring to Riem, which was the case which effectively said that welfare was not the paramount consideration in relation to Section 25. Lord Justice Baker agreed that it's not paramount, but it's plainly an important element in the court's analysis, and it is one of the relevant criteria, so it does have to be taken into account. Similarly, in relation to Section 25, it was determined that that was one of the relevant criteria. In particular, the relevant articles are going to be Article 5 and Article 8. Lord Justice Baker actually, in this case, on the specific facts of this case, acknowledged that there are some cases where something more was required in relation to the proportionality exercise, and on the facts of this case identified that where a placement's really far away from a child's home, it would be a greater interference with their Article 8 rights. So that's something that's worth bearing in mind when considering these sort of applications. If I could just have the next slide, please. So what are the relevant criteria? I'm going to just read through this because this is such a beautifully contained paragraph of questions that a court must ask. So this is very easily cut and pasted into any skeleton argument in relation to an application for a secure accommodation order. But the questions are: is the child looked after by the local authority, or alternatively does he fall within one of the other categories specified in Regulation 7, as I said, health authorities, education authorities? Is the accommodation where the local authority proposes to place the child secure accommodation, is it designed or have its primary purpose for the restriction of liberty? Is the court satisfied that the child has a history of absconding? So that's the test. It's probably worth mentioning that on the issue of absconding, the court has considered the definition of absconding, and it's not ever given any very clear guidance. It should have the definition as set out in the Oxford English Dictionary, is what was suggested. Absconding for very short periods and returning to a placement may not be absconding, but it may be that you still fall under the second limb, which would be that you could injure, that a child would injure themselves or other persons. If I could have the next slide, please. The fourth one is that it needs to be approved by the Secretary of State. Similarly, it is possible to place children from England in children's homes in Scotland. And so in those circumstances, it would need to be approved by a Scottish minister. And so then at number 5, does the proposed order safeguard and promote the child's welfare? So it is a consideration that has to be taken into account. And at number 6, is the order proportionate? So those have been included in the analysis. So every time a judge looks at an application under Section 25, they need to be looking at these points. I think previously a lot of judges would have said that actually the test was fairly strict, it was straightforward, and they didn't need to consider those, but they should be considering those now. So if you are looking to oppose an application for a secure accommodation order, it may well be that these are the 2 key points to be looking at, because the other points may answer themselves to some extent. In circumstances where a child's under 13, the placement must also be approved by the Secretary of State. I think the specific placement of that child, because obviously children under 13, one would hope, aren't in a situation where they are having to be made subject of secure accommodation orders, albeit it does happen. The relevant date for considering the criteria is the date of the hearing, and if the relevant criteria are satisfied, the court is obliged to make the order and set out what the maximum period is that the child can be kept. So that is what the test is as set out in Read B. It's very neat, and I think everyone who is faced with one of these applications will be very thankful to Lord Justice Baker for allowing us to have such a clear and concise account of what we need to look at. So just very briefly, because I know I'm running over, but in relation to the judicial responses to the shortfall in provision, there was a judgment that came out just a couple of weeks ago And this judgment from Mr. Justice Cobb was just the latest in a very long line of cases that followed Reety, and Reety was now about 18 months ago. That was where Macfarlane considered really the very grave issue that there was between the disparity between the number of children that needed secure accommodation and the number of places in secure accommodation. In this case, I mean, very briefly on the facts, this was a 15-year-old girl who was placed in a holiday let in North Yorkshire, where she was supervised by carers 24/7, and her liberty was restricted. But really very sad facts. This child had been, I think, in 16 placements in 12 months. 7 of those had been unapproved placements, and it was really quite a dire situation. So but what the judge did in this case was refer to the practice guidance that was made in November. That was President of the Family Division and Ofsted guidance. The court does need to be satisfied that if it's presented with a DOL application for authorisation, that steps are being taken to register the placement, and actually the court can adopt quite an active role in monitoring that sort of process of registration. There was also a report from the Children's Commissioner that was transcribed in part into the judgment, which set out some of the issue and also showed quite clearly how the issue seems to be getting worse. And the judge in that case asked that the judgment and the case papers be sent, some of the case papers be sent to the Secretary of State, because this is such a serious problem. The government has announced a consultation in relation to this issue in February, or not this issue alone, but certainly the issue of regulation of placements. And we'll have to wait to see what that says. But I don't want to take any more time. Thank you very much, and we'll move on to Tom.
Yes, thank you very much, Kate. I will be speaking about the deprivation of liberty safeguards, and I'll be speaking about 3 aspects of the DOLs in particular. Firstly, practice. If we could pull up the slides, please, Mona. Yeah, so I'll be speaking about 3 aspects of the DOLs. Firstly, practice, how to identify a deprivation of liberty in practice. Secondly, I'll be looking at procedure, how to go about authorising a deprivation of liberty if you have identified one. And then finally, I'll be looking at reform, what reform is on the horizon in respect of the DOLs. Now, in respect of the impact of coronavirus on the DOLs have not been formally amended by the Coronavirus Act 2020. And more broadly, the Mental Capacity Act has not been relaxed in any way. So the DOLs are certainly still in force. And on the 4th of May 2020, the Vice President of the Court of Protection, Mr. Justice Hayden, wrote to the directors of all adult social services to emphasise that nothing has changed during the pandemic in respect of the requirements to authorise deprivations of liberty. However, the UK government has produced some emergency guidance to help those dealing with DOLs cases on the ground. Now, that guidance is more aimed at adult social care and healthcare professionals, and 9 Gough Square has produced a webinar already on that guidance. This talk will focus more on deprivations of liberty as it relates to children and young persons, and some of the legal developments that have taken place in the last 12 months. So moving on to the first slide, the starting point in considering a deprivation of liberty is Article 5 of the ECHR, which guarantees everyone the right to liberty and security of person. It guarantees that no one shall be deprived of their liberty, save for in certain circumstances which are set out in law. And there are, of course, other convention rights which may run in parallel with Article 5. Article 8, for example, the right to respect for private and family life, and Article 6, the right to a fair trial. And it's obviously important to keep these 3 human rights at the centre of any assessment of a child's deprivation of liberty, as they'll often be pulling in different directions. All local authorities are considered to be public bodies and therefore required to act in a way which is compatible with these convention rights. And Lady Hale in Cheshire West reminds us that children and young people have the same human rights as the rest of the human race. So moving on to the next slide, the deprivation of liberty safeguards for the DOLs are safeguards which have been created within the Mental Capacity Act to ensure that any decision to deprive someone of their liberty is made following a defined statutory process. That process is set out in the DOLs. But this statutory authorisation process contained within the DOLs has two very important limitations. It only applies to 18-year-olds and above, and it only applies in certain settings, in care homes and in hospital settings. So for children who are under the age of 18 who are deprived of their liberty in any setting at all, they will require a court authorisation. And in the second part of this talk, we'll be looking at that authorisation process. In the next slide, I set out what a deprivation of liberty constitutes. A deprivation of liberty involves three elements, and all three elements must be satisfied before a court can authorise a deprivation of liberty, or before one can be authorised under the DOL's administrative process. That is, namely, that there's an objective confinement, that there's a lack of valid consent, and that confinement is attributable to the state. And I put the relevant case law on the slide there. So turning to the first component, the objective confinement component, on the next slide, there we go. In respect to the objective component, the Supreme Court in Cheshire West held that a person who lacks mental capacity is deprived of their liberty if they're not free to leave and under constant supervision and control. You should conduct an analysis of whether those circumstances are merely restrictions which do not require authorisation, or deprivations which do require authorisation. And the distinction between a deprivation of and a restriction upon liberty is one of degree or intensity, and not one of substance. It's a question of degree as to whether those restrictions are sufficiently intense to move from being restrictions to being deprivations. The Court of Appeal has put a gloss on the not free to leave element of the definition, saying that it means not free to leave that accommodation permanently. So thinking about the current situation and COVID-19, for many people who were not on a dole before the lockdown, temporary changes to their care plan during the lockdown will not normally amount to a dole, because that not free to leave element is not permanent. Now this gloss comes from the case of Birmingham City Council against D, the Court of Appeal case. Now this case went to the Supreme Court, as Kate has already outlined, on a separate issue. But this gloss on the test, that survives the Supreme Court's appeal. Now I've focused in considering the objective element on the not free to leave element, as that is where professionals and practitioners should also focus their analyses. Then move on to consider whether they're under constant supervision and control. And I approached the analysis in this way, as I would find it very difficult to envisage a situation where P, or the child, is not free to leave, but is also not subject to constant supervision. If you have the not free to leave element, you're very likely to also have the constant supervision element by virtue of the care plan in place. Moving on to the next slide, I've listed on this slide some factors which may point towards objective confinement. This list isn't an exhaustive list, and I don't suggest that just one of these factors necessarily amounts to objective confinement, but they are factors which may point towards objective confinement. So they include factors such as the doors of the property being locked, a 2-to-1 package of care, restricted access to personal belongings, restricted access to the internet, police being called if the child goes missing. The more factors you can tick off this list, the more likely it is that there is objective confinement for the purposes of the first element of stalk. Moving on to the next slide, the former president of the Family Division, James Munby, in Re AF, set out guidance on the interface between care proceedings and deprivations of liberty. This is an excellent judgment for child protection lawyers who deal with a lot of DOLS cases. At paragraph 43 of the judgment, he addresses whether very young children can actually meet that objective element. He says that a child aged 10, even if under pretty constant supervision, is unlikely to be confined for the purposes of stalk component A. A child aged 11, if under constant supervision, may be so confined, and a child who is under constant supervision who has reached the age of 12, the court will more readily come to that conclusion. So taking a step back, the important point to note about paragraph 43 of REAF is that if a child aged 10 and under is under constant, pretty constant supervision, it's unlikely to amount to objective confinement at all. So you then don't need to go on and consider the second and third stalk components, valid consent and state attribution. The logic being that any child of that age would be confined in any event. Moving on to the second element of the test, the second element will be satisfied if there is a lack of valid consent. And there has in the past year been a very important case on the issue of consenting to a deprivation of liberty, the Supreme Court decision in Re D, which Kate has outlined. Re D held that a person with parental responsibility cannot consent to circumstances which would otherwise amount to a deprivation of liberty on behalf of a child aged 16 or 17 who lacks capacity. Now, I've put there in the test for ease of reference that a local authority with parental responsibility cannot consent to a dole for a 16 or 17-year-old either. Now, that was something which was agreed between the parties at the Supreme Court hearing. So the court didn't need to deal with this point in its judgment. There are, however, some passing comments in the judgment on that difference between a local authority with corporate parental responsibility and parental responsibility, querying its logic. But the principle remains that local authorities cannot consent to a dole on behalf of a child of any age. That was the position before Re D, and that's the case post Re D. It was also suggested in Re D that this distinction between 16 and 17-year-olds for whom parents cannot provide valid consent now, and younger children for whom parents can continue to provide valid consent, seems arbitrary, suggesting that the human rights analysis that applies for 16 and 17-year-olds, which led the court to the conclusion that it reached, is the same analysis for those under 16. So the Re D principle could apply in the future to those aged under 16, but there's no clear case on that point yet. But local authorities should apply parental consent in cases such as these, where the child is under 16, with a degree of caution. Moving on to the next slide, children aged under 10. So taking a step back from that general test and considering various different ages of children. For children aged 10 and under, the President's guidance in REAF applies. A child aged 10 and under, even if under constant supervision, is unlikely to be confined for the purposes of the first stalk component. So you don't need to go on to consider the subjective element for children under age 10 and under. Moving on to children aged between 11 and 15, a person with parental responsibility, but not the local authority with parental responsibility, can still now consent to circumstances which would amount to a deprivation of liberty on behalf of a child who lacks Gillick competence. So for children aged between 11 and 15, parents can continue to provide their consent. A social worker is able to assess a child's competence to consent to their confinement. However, evidence from a child and adolescent psychologist or psychiatrist may be more appropriate. If valid consent to confinement is provided in respect of a child by a person with parental responsibility, there can be no deprivation of liberty. Moving on to the next slide, I've put a very brief practice point up on this slide. You should ask yourself whether the person with parental responsibility is able to exercise PR appropriately. The court has given guidance on the appropriateness of a parent's exercise of parental responsibility. If a parent's past exercise of PR has been called into question, it may not be right or appropriate to permit that parent to consent. So, for example, this might be relevant to the deprivation of liberty of a child who is subject to a care order, where the threshold criteria has been met or findings have been made against the child's parents. It's unlikely in those circumstances that the local authority will be satisfied that parental responsibility has been exercised appropriately. Moving on then to consider young persons aged 16 and 17, The Mental Capacity Act applies to those aged 16 and over, and therefore all of the principles of the MCA apply. A young person aged 16 and above must be assumed to have capacity unless it's established that they lack capacity. That's section 1(2) of the MCA. If a young person lacks capacity, neither a person with parental responsibility nor a local authority with parental responsibility can consent to their deprivation of liberty. Some more practice points on the next slide. Firstly, where a parent does consent in respect of a child under 16, it's important for local authorities to ensure that parental consent to those particular circumstances giving rise to the confinement are clearly documented and recorded on that child's file. This is, of course, hugely important. Secondly, any decision by the local authority should adopt a common sense approach. It shouldn't be forgotten that parental consent is not unlimited. So in this respect, the local authority should have consideration to the type of confinement when assessing parental responsibility. The more coercive the confinement, the more likely it is that the decision will fall outside the scope of parental responsibility. The final point to note is the duty on local authorities. Local authorities are under a duty to consider whether children in need or looked after children are subject to restrictions which do amount to a deprivation of liberty. Moving on then to the final category of child, young adults aged over 18. Again, the MCA will apply to those aged 18 and over, so they'll be assumed to have capacity unless it's established that they lack capacity. If they consent to the deprivation of liberty, they are deemed not to be deprived of their liberty. The final stage, the third stage, is state attribution. State attribution, which should be on the next slide. I think there are some slide issues here. Maybe I'll carry on talking and hopefully the slides will catch up with me. State attribution is the final stage, the third requirement in STORC. The final component is that public body, such as a local authority, responsible for the situation on the ground that has created the deprivation of liberty within Article 5. If yes, then the deprivation of liberty shall be attributable to the state. State attribution is interpreted very widely by the courts. There is a case called Staffordshire against SRK 2016, EWCA Civ 1317. In that case, the Court of Appeal confirmed that a privately funded care package in a person's own home would give rise to a deprivation of liberty, which is imputable to the state. So in public care proceedings, this part of the test, this third element of the test, will almost invariably be met. I think I'm now on slide 17, Mona. If you have, so I think it's further back, still dealing with practice in the first section. Back again, I think. All the way back, yeah, all the way back, further back, further back. There we go, there we go. So that is the test. Those are the three elements of the components to look out for in practice. Before we move on to consider the procedure for authorising a deprivation of liberty, I've got three examples of situations which may or may not amount to a deprivation of liberty. Now, I do believe on Zoom there is a Q&A function. So perhaps when I go through these examples, you can indicate on the Q&A whether you think this is a dole or not a dole, and you can say on the Q&A. And I think Tim will be able to keep tabs of the answers. Maybe we can book in some repeat training if needs be. Example number one. John is 14. His mother has left the family home and has been in a relationship with a registered sex offender. John is placed into care after his father's arrest. He's made the subject of an ICO. He's got a moderate to severe learning disability and attention deficit hyperactivity disorder. At the unit, he's accompanied by a member of staff when he leaves, is not allowed to be alone with a member of staff or another child, and is on 2-to-1 support. He does not have capacity to make decisions, but has stated that he wishes to remain at the unit. His parents consent to him being there. His allocated social worker on behalf of the local authority consents to him being there. Is this a dole or is this not a dole? Perhaps I'll be able to see what the answers are. Maybe Tim can feed back. There we go. Dole, not dole. Well, this is likely to be considered a dole. In terms of the objective element, the first component, John is not allowed to be alone with one member of staff, is accompanied by members of staff when he leaves, so you can infer from that that they bring him back, and he's on a 2-to-1 package of support. So the circumstances satisfy the objective criteria. Moving on to the subjective element, the second element of the Stork test, the local authority cannot consent to the deprivation of liberty, so it doesn't matter that his allocated social worker consents to him being there. The parents also cannot consent to the dole, but they could consent to this particular deprivation of liberty because he's 14, but in this particular case, the parents could not be said to consent to the dole given the circumstances which have led to the care proceedings. It cannot be said that they've exercised their parental responsibility appropriately. In relation to John's consent, he lacks capacity and therefore cannot consent to the deprivation of liberty. So this is likely to be a deprivation of liberty. Moving on to the second example, Adam is 17. There are no concerns in respect of the appropriateness of the exercise of his parents' parental responsibility. He has very complex needs which require admission to a specialist care and education facility. Within the facility, he's accommodated by a member of staff when he leaves and is not allowed to be alone with a member of staff or another. So similar objective element. He does not have capacity to make decisions, but has stated that he likes the facility and is stimulated by the education program. His parents consent to him being there. And I've said at the top there that there's no questions about the appropriateness of the exercise of his parents' parental responsibility. Anonymous attendee says, not a dole. This is likely to be a deprivation of liberty. The objective element is the same. Christabel Ashby says dole because over 16. There you go. His parents cannot consent on his behalf post-re-D as he's 17, even though there are no concerns with the exercise of their parental responsibility. In relation to his valid consent, he lacks capacity and therefore cannot himself consent to the dole. So again, this is likely to be a deprivation of liberty. Moving on to the third example, Rebecca is 17. She has associated with gangs in East London. She returns to her mother's care. Her mother is unable to prevent her from leaving the house and associating with gang culture. Rebecca becomes the subject of an ICO. The local authority cannot find a suitable secure accommodation placement within the jurisdiction. The local authority have found a residential unit called the Willows. The statement of purpose states that when residents attempt to leave, they are encouraged back by staff who are trained in using appropriate restraint techniques. Do you think this is a dole or do you think this is not a dole? This is likely to be a dole. This is very similar to a recent case of mine where the judge initially refused to make the deprivation of liberty order on the basis that the local authority evidence was incomplete. The judge wanted certain evidence in the local authority's witness statement. She wanted the social worker evidence to include full circumstances of the deprivation and the mechanisms used at the facility to restrain. She wanted the reasons why a secure accommodation unit was unavailable or unsuitable and the efforts gone to find secure accommodation by the local authority. She wanted the restraint policy used at the residential unit, and she also wanted the programme of the residential unit or its terms of reference or its statement of purpose, which she said should be appended to the social worker's statement. Moving on to the last slide on practice, which sets out some guidance. If you are in doubt about whether a case is a deprivation of liberty or not, you should ask yourself, is it at least arguable that the circumstances amount to a confinement? If so, you should take it to court. That's guidance given in the case of Re AF. So that is the part of the presentation dealing with practice. Moving on to the next part of the presentation, which deals with procedure, authorising a deprivation of liberty. After you've identified that a deprivation of liberty is in existence, the next question is how you go about authorising it in court. Now, remember that the doles do not apply to those aged under 18, so it has to be court authorisation. In respect of children under 16, the local authority will need to apply to the High Court for the exercise of its inherent jurisdiction in order to authorise a deprivation of liberty. In Re AF, there is in paragraphs 49 to 51 a very useful summary of the relevant procedure and evidence for an application under the inherent jurisdiction. The key elements I've set out on the next slide. Firstly, if a substantive order is to be made authorising a dole, there must be an oral hearing in the family division, though this can be before a Section 9 judge. A substantive order must not be made on paper, but directions can be given on paper. Secondly, the child must be a party to the proceedings and have a guardian. The President's guidance is that the guardian should see the child unless there is a very good child welfare reason to the contrary. And the child, if of an age to express wishes and feelings, should be permitted to do so to the judge if that's what the child wants to do. Bulk applications are not lawful. Moving on to the next slide, which sets out the evidence which should be attached to the substantive application. The evidence should include the nature of the regime, identifying the features of the regime which involve confinement. Secondly, the child's circumstances, identifying those aspects of the child's situation which is said to require the child be placed as proposed, and why it is said the proposed placement is necessary and proportionate. And finally, the views of the child, parents and the IRO, the most recent care plan, the minutes of the most recent LAC review, and any reports relating to the child's physical and mental health. There is also on the President's Orders pack online an example of a deprivation of liberty order, which can be added to the application. Moving on to the next slide, if when care proceedings are issued, there is a real likelihood that authorisation of a dole may be required, the proceedings at that stage should be issued in the family court but allocated to a circuit judge who is also a Section 9 judge. Where the care proceedings have been allocated to a judge who's not a Section 9 judge, but it becomes apparent during the course of proceedings that there is a real likelihood of authorisation being required in respect of a dole, steps should be taken, if at all possible, without delaying the proceedings, to reallocate the proceedings to a circuit judge who is also a Section 9 judge. Moving on to the next slide, the care proceedings will then remain in the family court and must not be transferred to the High Court. The Section 9 judge conducting the two sets of proceedings, the Care Act proceeding, the care proceedings and the inherent jurisdiction proceedings, can do so simultaneously. Moving on to the final slide on procedure, it should be remembered that leave is always required in deprivation of liberty cases. Section 100 requires the court to be satisfied that the result the local authority wished to achieve, that is the lawful deprivation of the child, could not be achieved by any other order. Therefore, you'll need to satisfy the court that either secure accommodation is not appropriate or sufficient steps have been taken to find a secure placement, but unsuccessfully. Moving on to the next slide. Persons aged between 16 and 17. If the child is between 16 and 17, the Mental Capacity Act applies, but the doles do not apply. Authorisation can be through the court's inherent jurisdiction, the inherent jurisdiction of the High Court, or the statutory powers of the Court of Protection to authorise the deprivation of liberty. It's not possible to use doles for young persons aged 16 and 17, but it will be possible to use the new LPS system. Moving on to the next slide, which deals with young adults aged 18 or over in care homes and hospitals. Well, the doles will apply to these individuals. And moving on to the next slide, young adults aged 18 or over in other settings. For young adults in different settings, such as residential units or supported living, family placements, authorisation should be sought from the Court of Protection, pursuant to Section 4A3 and 16.2a of the Mental Capacity Act, and a streamlined procedure is available for such authorisations. Moving on to the final slide on procedure. Obviously, authorisation is very important, and the level of damages available to individuals who have had their Article 5 rights infringed by a local authority reflects that importance. I have put on the next slide a very brief summary of the procedure for authorising a deprivation of liberty in respect of children. As you can see there, for children aged 10 and under, the guidance from the President in Re-AF is that even if the child is under constant supervision, that's unlikely to amount to confinement. For children aged between 11 and 15, parents can continue to provide consent. Local authorities with PR cannot. The High Court has jurisdiction. The Court of Protection does not. The DOLs do not apply, and nor will the LPS. For children aged 16 and 17, parents cannot provide their valid consent. The High Court does have jurisdiction, so does the Court of Protection. DOLs do not apply, but the LPS will apply. So moving on to the final part of the presentation, very briefly, because I'm aware of the time, which deals with reform. As you will be aware, the UK government and the Welsh government, alongside dealing with the pandemic, are also implementing the new Liberty Protection Safeguards system. This arises from a House of Lords Select Committee report from 2014, and in the same month, the Cheshire West decision significantly widened the definition of a DOL. The Law Commission then reviewed the DOLs and called for their reform, which ultimately led to the Mental Capacity Amendment Act. The target implementation date is October 2020. I've set out on the next slide a brief overview of the Liberty Protection Safeguards system, which I won't go through in any great detail now. But the important point on the next slide is that the Liberty Protection Safeguards will apply to those aged 16 and over. It also trims down the administrative process. There will now just be 3 criteria for authorisation under the new process, namely mental capacity assessment, a mental disorder assessment, and a necessary and proportionate assessment. Finally then, there has been a lot of sector concern about what the impact of coronavirus is having on the implementation of the LPS. Alex Wakefield from DHSC has indicated that the UK government is now considering the implementation timetable of the LPS in light of the pandemic, and the government has indicated that the sector should not prioritise LPS preparation. So in light of the pandemic, it seems that an implementation deadline of October 2020 is going to be difficult. Therefore, the court process will remain for 16 and 17-year-olds for a little longer, it seems. Thank you very much. I'll hand back over to Tim now.
Tom, thank you very much. I'm just looking at the bottom of the screen to see if there are any Q&As coming up, and a few emerging. You can either use the chat function, which is next to the share screen, or indeed there's a Q&A section as well, and you can even anonymize your questions if you want to. So please feel free to type away, and I'll have a look at things as they arrive in. One of the things that I can see somebody asking straight away is whether the slides might be made available online, and I think the answer to that is yes. I think the only point we'd make is that it's for your own purposes only, but other than that, I think they can be emailed out to you by Mona. If you get in touch with Chambers or any of the clerks, they'll be able to send them to you. Probably you could get them directly from Tom or Kate as well. T Jones at 9 Gough Square or K Lamont at 9 Gough Square .co.uk respectively. So any of those ways would enable you to get access to those slides. But we're all, I'm sure, very grateful to Lord Justice Baker, who has this knack of giving judgments that set out a convenient checklist. There's another one, I think, in NAIs, isn't there? Or at least 2 of his judgments in NAIs, which set out sort of 10 or 12 aspects of the evidence that you need to consider, so that for him to have added one to secure accommodation really does help us all in quickly, because it's always quick, isn't it, for secure accom, in formulating the arguments, whether they are pro or anti the application that's being sought. Kate, any developments since lockdown or since the emergence of coronavirus in either secure accom or removal cases generally?
Well, there are a couple of points. Firstly, in Re-S, I think Mr. Justice Cobb in Re-S was quite clear that actually these issues were not issues of coronavirus, because the issues in relation to the provision of secure accommodation have existed long before coronavirus took its toll, but it's likely, of course, that it might have had a even further impact on staffing levels and things like that. I know that personally I've had an application since lockdown. Actually, in this case, it was for a deprivation of liberty authorisation. But I know His Honour Judge Tolson made it very clear that he had a number of applications in that week. Where local authorities had been unable to identify placements because of lockdown and everything else. So it's clearly a very significant problem, and continues to be a significant problem during coronavirus, probably even slightly worse. But yeah, so
I know anecdotally that local authorities are applying a sort of a traffic light system to their cases, and that in terms of their own social work teams deployment, only those at the very highest level of seriousness will be able to have direct personal input from social work teams. I'm sure that's going to have a bearing upon the cases that are being considered now, and potentially the cases that will be considered as the restrictions are lifted.
Yes.
Tom, apart from memorising citations to High Court cases, as far as Dols is concerned, is there an issue about making a decision on where to issue your application when faced with a potential Dols? I mean, would you go to the Court of Protection or the Family Division? Your table sets things out quite clearly, but as a child gets older, is there a judgment call to be made there?
Yes, there is. Obviously, when the child is 16, 17, the Court of Protection does have jurisdiction. So there is a question as to whether you should be taking something to the Court of Protection, remembering, of course, that the Court of Protection will not have jurisdiction if the child has capacity. So you should primarily, the guidance is that you should be starting these applications in the High Court, and then getting the authorization from the High Court. But obviously, when the LPS comes in, you won't need to go to court for 16 and 17-year-olds. That will be covered by the administrative authorization process contained within the LPS.
I see. And another point that I think we've discussed before in Re D is Baroness Hale. I mean, often it's the case with Supreme Court judgments, isn't it, that there's something there for everybody, and you can argue it both ways on what they have to say. But Baroness Hale's speech seemed to leave us hanging a little bit about the ability or consent issues where children are approaching or above the age of 16. Again, is there any emerging views on that you've become aware of?
Well, she hints that the same analysis which got the court to the conclusion that parents cannot consent to confinement of their 16 or 17-year-old child, that same analysis which is conducted, which is largely a human rights analysis, that analysis could equally apply to those under 16. But the question asked at the Supreme Court was in respect of parental responsibility for 16 and 17-year-olds. So the court didn't actually address that issue specifically. But it's likely that we will see some further developments on that issue in due course.
Thank you. Well, we're happy to stick around a little bit for a few more minutes, just in case any questions emerge from there. But for those who have attended this afternoon, thank you very much indeed for taking the time to listen to our talks. I hope they've been useful. Please do get in touch to let us know what you thought about it. There's going to be another family seminar coming up, I think next week, and if not next week, the week after, certainly. So keep an eye on Chambers' website, our Twitter feed, and I think even this seminar can be viewed on Chambers' YouTube channel, which has the other seminars also available to view as and when you would wish. So thank you very much for attending. And as I say, I hope it was useful. Thanks both to Kate and Tom for their talks, and look forward to seeing you again in due course.